Hello Ali, I'm Nicola, and today I'm going to talk to you about your employee status with HPC and your whether you're entitled to any statutory redundancy pay or not. Under Section 230 of the Employment Regulations Act 1996, we are given a definition of what an employee is, but to be quite honest, it's of no help for us today because it's very vague and very wide. So we're going to look to the courts and the common law and what they say. And the current test, and the one most often used, is a multi-composite test. And this has three different points that need to be shown in order for employee status to be established under this test. And the first of those is personal service. This means that the person must do the work themselves, that the person cannot substitute the work for someone else. And this is under the case of Express and Echo publications in Tanton, which you are able to substitute yourself and find yourself a substitution. However, under the case of McFarlane and Glasgow City Council, if that substitution is limited, it may still suffice to establish personal service. And in your case, you are limited in that you can substitute yourself with another colleague, but should that not be available to you, you have to inform HPC so that the customer is not lost and the contract with that customer is not lost. So I do believe that those are limitations enough to show that this is a personal service that you offer to them. The second of these arms is that the employer must have control to a sufficient degree. Now, the control under Montgomery and Johnson Underwood, the control must be background control. So it's not a control of everyday life, it's a control of the person and the job that they do. So when you're at work, are you in their control? And I think that you wear a uniform and they provide you with contact details for customers. They dictate who you can and can't work for. So even though you are able to find other work, you can't work for one of their competitors. Now, I think that's evidence of them having control to a sufficient degree over you and what you do whilst you have your time with them. The third one of these provisions is that all other provisions of the contract must be consistent with it being a service contract. And the fact that you wear uniform and that you man the showroom one Saturday every month, I think is enough to show that a service contract exists. So I think that, under the multi-composite test, you have a good case for showing that you have employee status. But there are other tests that can be used, and another one of those is the control test, which the case of Younes and Noakes shows us that this, again, as mentioned before, the control must be a background control and not a control over your everyday life. And for the same reasons as I've discussed before, I do believe that HPC have a sufficient amount of control over you whilst you're at work. And then the second one of these other tests is the integration test. Under Stevenson, Johnson and Harrison and McDonald versus McDonald's and Evans. And this, basically, Lord Denning described this as does the person do other things apart from his main job? And I think that in your case specifically, the fact that you man the showroom for one Saturday of every month on top of your main salesperson's job shows that you are integrated into the business, because if you couldn't do this on those days, they wouldn't be able to perform their work. No money would be made. They wouldn't be able to have a business. So I think for those reasons, this would be proven, would help your case. Another test that could be looked at is the economic reality test, generally used to show whether someone is employed by a company or is self-employed, by looking at the economics. Basically, the questions that the court would ask is, could this person make a profit or loss during the course of his business or day, or work rather? Can they hire and fire staff? Do they use their own tools? Do they have a financial risk involved? Have they put any money in? And the answer to all of these questions in your case is no. So on that basis, again, you would have a very good case for showing that you have employee status. And then we have the mutuality of obligation, which has two elements that must be shown. The first of which is that a contract must exist, and as I've already discussed, I do believe that you have shown that you have a service contract with HPC for the reasons discussed before. And the second part of that is that there must be a mutual obligation between the worker and the employer or the company for an offer of work and for an acceptance of work. This is under the case of Carmichael and National Power. I do think that this could be problematic for you, but if you use the other tests, I think you would be all right. And finally, the courts would then look to, if all else fails, they would then look to the intention of the parties. In the case of Hall and Lorimer, it was stated that the courts will paint a picture of the situation as a whole. So they'll look at everything, and look in every nook and every cranny, and unearth all the information that they can, and paint a picture, and see that in the course of your work, are you, an employee, or are you self-employed for whatever reason that they may find. So to sum up, really, I think that under the multi-composite test, you could have a very good case for showing that you have employee status and therefore should be entitled to statutory redundancy pay. But should you need anything else, Ellie, please don't hesitate to contact me. I hope that's been of help to you today. Okay, thanks.